This is a part-heard appeal in the matter of Pickering Fishery Association and Secretary of State for Environment, Food and Rural Affairs.
Yes, Mr. Fraser.
My Lords, there are two items that I promised to provide overnight.
Yes.
Your Lordship should have a Treasury tagged clip of documents in front of you. I think it might just be coming now.
I have got something in font size 3.
Thank you so much.
I think that might be one of my learned friend's documents.
Yes, it's another eye test.
So,
right, so yes,
But if
note on bundle references to our BMPL.
yes, so there are three distinct documents in this
Right.
short clip. The
Okay.
first is a note on bundle references, identifying by reference to page 4 of the supplementary bundle, where the individual elements of the River Basin Management Plan are found in the bundle.
Yeah.
And over the page, the individual elements of the summary programs of measures.
No, that's really helpful, thank you.
And then the second document is headed Joint Note on Transposition. This is an agreed note between the three parties, identifying
Okay.
the corresponding regulations to the relevant articles of the directive.
Right.
And then the
that's
third document, my lords, is
helpful too.
a more detailed transposition note that's prepared by DEFRA at
Yeah.
the time when the regulations were first introduced, in case that
Okay.
assists in providing any further information. The third document should be headed Department for Environment, Food and Rural Affairs.
It's a schedule.
It's a slightly more detailed note.
It's like that.
Yes, it starts with the heading Department for Environment, Food and Rural Affairs, and it's not a document that we've produced for the purpose of these proceedings.
No,
It existed already.
does it have a date actually, the document?
I can find that out, my lord. I don't know it off the top of my head, but I'll certainly find out. But it was produced
Yeah,
at the time when the 2017 regulations were first prepared.
no, that's
and
fine,
made.
okay. If you can find the actual date, I think it would help us to have that. But it's very helpful, thank you. Thank you all very much for the efforts, and your teams for the efforts put into agreeing those and collating those materials for us. Thank you very much. If you've led on that, Mr. Fraser, especially thank you to you. Thank you.
has indeed.
Thank you. Yes, Mr. Kimblin.
Ms Pindham has led on the production of an agreed bundle of materials from the environmental permitting regulations, which I think have reached your lordship's desk in a small file, black file, which I see my Lord Justice
Oh,
Holgate
this
has picked up.
folder, yes.
I don't propose to say anything about that, that was requested by the court, and
Well, I'm sorry, this is requested because you introduced the 2016 regulations yesterday. There's quite a lot of material here. We're going to have a note which tells us what we should be focusing on and why.
indeed, yes. But I'm not going to spend time on it now because that plainly will intrude on
Yeah.
the first respondent's
Right,
case.
well, I think we do need to have that in fairly short order after the hearing.
It will be very much reflective of what is contained in the authorities bundle, which is the Secretary of State's guidance on these regulations.
Yeah.
So there will be nothing that's particularly startling in that.
No. All right. Well, I think we're going to have to ask for that by 10 a.m. tomorrow.
Yes, but it's very easily produced.
All right.
So far as
Thank you.
a single sheet of paper is concerned, there is on page 645 in the first bundle of authorities, there is an extract from a website which was produced at extremely small font and which is completely illegible.
Right.
Whether what we've managed to produce in replacement of that is any better is a matter of debate, but that is the absolute best that we've been able to do in terms of printing.
Which paragraph do you want us to look at?
So it's the first 5 paragraphs.
Thank you.
And it is referred to in our response to the OEP's intervention. That is where that comes from. It goes to question of purpose.
The date on the bottom of the document on page 646, the 20th of May 1977.
Yes, it's an error. It's a typo.
97 document.
Yes,
Yeah, this isn't it. You get that from the title.
Yeah. So it's 97, isn't it?
yes, it's a typo.
Right, so we can correct that to 1997. And this goes in at page 646 in the authorities bundle.
My lord, yes.
Let's do that now. Which volume is that?
It's volume 1, my lord.
Thank you.
We have already got a 646. So I think this might be 645A, 645 and 645A.
That may be a better nomenclature, yes.
Oh, I see. Yeah.
It's because it's the same thing.
Yeah.
You've put in on 2 pages, helpfully, what was on 1 page, so
That's what's happened.
Yeah,
Exactly.
no, that's done now. We've done that. All right. Thank you for that.
The next stage terrifies me. That we have produced at this size
Oh,
the material which is
right.
which has caused Your Lordship some difficulty in reading the programme of measures. And I haven't had it put on Your Lordship's desks because of its size.
Quite large.
So-
Could you just hold? Would you mind very kindly just holding it up so we can see what it actually looks?
That is what we're contending with.
is that the A2 or A1 version of what we had
Yes.
in
So
A3?
it's been printed
A1.
where it is definitely legible, but it's not terribly manageable.
Right. Can I
So-
make a suggestion? Which are you? I imagine that Mr. Wolfe is going to be referring to that document this morning.
Only barely.
Only barely. Well, what I was going to suggest is that somebody could very kindly fold it into a something smaller size so that we can actually carry it around more easily. Is that possible? Can somebody do that for us, please?
You can get files big enough for documents like that.
Yes.
Because in the technology and construction core, we often have plans as big as that.
Right.
What we've done is put them in a scroll, so they're wrapped up and they're there.
Oh, I see. Right.
And for the purposes of drawing the court's attention to that, the purpose of providing those in particular is so that the court can see at pages
Yeah.
176 and
Understood,
180.
No, it's thank you for doing it, because actually it's probably the only practical way that you could have attended to our request. Yeah, if it's possible to put them in some sort of smaller folder, i.e. fold once or twice,
Yes, of
And-
course.
and then put in folder, it's easier to manage when
Of
we
course.
come to sit down and look at things later. If you've got them flat.
Yes. And on the outside, we'll put the relevant page number.
Yeah, no, that would be helpful.
So we know which one.
So I
is which.
appreciate that's a rather boring task for somebody to have to do, but it will help us a good deal if that is done for us,
Very well.
please. And I suppose it had better be done outside the courtroom so as to avoid disruption.
Well, happily, we have a very large table outside.
Good, okay. Well, that's really helpful. Thank you for the efforts
So
that have been
the-
made.
All that will then become still clearer, because I promised to do this, to flag those water bodies which are referred to
Yeah.
in the programme of measures. One sees those via their, I think they're GB references, they're long numerical references in column 8 on page 176 and 180. You can see those water body specific.
Will they be identified for us?
Yes,
So we don't have to try and guess.
yes,
There's no row numbers, are there? But so somehow you need one sheet of paper
Yes.
telling us what to look at.
exactly.
Please.
No, well, fine. Thank you for doing that. And for the work that's still to be done to put the materials in a
Cool. Thank you
easily
very much.
manageable form. Thank you.
Thank you.
Thank you for all of those efforts that have been made overnight, preparing and collating documents. Right, so Mr Wolf.
Lord, can I just pick up one point arising from those exchanges, which is
Of course.
the EPR note that you're going to get tomorrow. We would obviously appreciate an opportunity to respond to that. I wonder if we could do that by first thing Monday.
Oh, on the permitting regulations.
Well, I thought that we were just asking which of the regulations we're being asked to look at.
Ah, I see.
I think an agreed note on which are the salient regulations for us to pay attention to. Are you going to be referring to these in your submission?
No, I'm not. No, I'm not. Because if it's simply a list of please look at these
I think
regulations,
so,
that's
yes.
fine. If it's like submissions on
No,
that's
we're not inviting submissions. Simply to make, as my lord said, to make the task of going through quite a lot of material easier for us, just to highlight the passages that the parties would like us to focus on in particular. I think 10 a.m. tomorrow is a reasonable.
I misunderstood the task, my lord.
You know, I think that's the best. That's the best task. Fine. So that deals with that concern. Thank you very much, Mr. Wolf. Yes.
My lord, I'm
You will not suffer by that loss of 10 minutes for admin.
My lords, can I start, if I may, just by reminding the court very briefly of the context for all of this, because although it comes to this court as a fairly rarefied point of law, there is of course a fishing club involved.
Yeah.
Just very briefly, supplementary bundle tab 5, you have Mr Smith's witness statement. He speaks for the Pickering Fishery Association. I'm not going to take you through the paragraphs. The simple point, my lord, is this: the Pickering Fishery Association has private fishing rights on the Upper Costa Beck. Second point, that was a healthy and successful fishery in the 1960s and following, but from the early 2000s it has now become effectively useless to the fishing club, and that is why they've raised these issues.
Yeah.
They have raised them, and this is in tab 6, with the assistance of Mr Kelton from Fish Legal.
Can you tell us roughly how many members there are in the club and the association are synonymous, really, are they?
Maybe
They're
in
one.
here.
So they're one and the same thing. I think you're getting some signals from behind.
130, I'm told.
130. Just that's an approximate number, obviously. Thank you.
Mr Kelton's witness statement is at tab 6. He deals with matters in chronological order, and obviously the documents to which he refers were all before the judge. I just want to touch on a couple of tiny points. He deals with the earlier history in the first few paragraphs. Can I pick it up at paragraph 22, if I may? This is in 2021, where the club, with Mr Kelton's assistance, were pressing the Environment Agency to review and upgrade the permits for the 3 particular point sources which are
Sorry,
of
this is
concern. Paragraph 22, I'm sorry.
Sorry, no, my fault.
They have been pressing, and indeed the history goes before this,
Yeah.
pressing for review of the permits about which they're concerned. Just to signpost ahead, the Secretary of State accepts that these particular point sources are contributors to the failure of the fishery. 23, again not contradicted, he says there has been no serious assessment by the agency of how to improve the regulatory controls for the sewage treatment works and the 2 fish farms. He then picks up the process coming into the RBMP cycle, which has multiple stages over 2 or 3 years.
Yeah.
Paragraph 27, last few lines in 27, he asked, by reference to earlier DEFRA guidance, for disclosure of what he, and you'll see in a few minutes that CIS guidance calls gap analysis. That is an analysis which we say is required as part of the review process leading into the RBMP process. It's the assessment of whether the measures in the previous plan have done what they were supposed to do, and that's the part of the process of developing new measures. 32,
Yeah.
this is 2021 by this point, he asks for a specific, it's referred to there as a review of the updated measures. That is a reference to the regulation 12.6 process. And 12.6, I'll check this to this in due course, is the foundation for our ground one. So he says, are you or have you done this in the lead up to the RBMP, which on our case would be a necessary part of that process. Paragraph 35.
Yes.
At that point, and he quotes the passage from the EA letter, this is in the quote, the claimant's wrong in its assertion the agency's acted unlawfully in its application of the regulations. There has been a review of the programme of measures for all water bodies in general and Costa Lake in particular, as is required by Regulation 12.6. The judge mentions this. So at that point, the agency was accepting the proposition of law that there needed to be a water body level 12.6 review. A position from which they subsequently resiled and which they now contest. At 39, Mr. Kelton picks up the consultation process and he explains how, on behalf of the club, he put in a consultation response, as it were, under protest. We can't respond properly because we haven't got from you what we should have had arising out of the review process.
That's 39, is
That's
it?
39. The point that we'll also be canvassing about a meaningful consultation.
Yeah. Yeah.
And then at 42, there's some pre-action correspondence. 42 says this, the agency provided a second pre-action protocol response, which it said was to be read with its first response. First response had said Regulation 12.6 measured applied at water body level, but now argued that the duty applies at the level of the River Basin Management Plan, River Basin Management District, and so on. So that was the flip-flopping of the agency's position, and that's, of course, their position in these proceedings.
Before you go away from 39 and 42, though, one of the consultation questions to consultees was an invitation, wasn't it, to the consultees to identify what measures consultees considered were missing.
Yes.
And it was that, I think, that part of the fish legal response was that they just couldn't tell what was missing.
How can we tell what's missing? You haven't given us the basis for it. So in a way, the question is an odd question on the agency's case.
But wouldn't it be possible for an individual consultee to say, you keep telling us it's the 2016 regulations, we've seen that they've not delivered a result so far, which is acceptable, but isn't sometimes with expert assistance a party able to say, well, if those regulations are applied properly, these are the measures which should be considered?
Well, they had been saying that.
Or are we actually looking at something as far as technological design issues in this exercise?
Well,
how far does one go?
Well, it's fair to say that the Fish Legal has said, and I've shown you a little bit of this, consistently over time, please review these permits. These permits, the conditions in these permits are not adequate for this purpose. Please review these permits.
Mm.
What it didn't have, and we say it should have had for the Regulation 12.6 and so on process, was the agency saying this is what we are proposing to do in the next RBMP cycle.
But
we can-
reviewing the permits may sometimes require extra infrastructure or kit.
Absolutely. Well, we haven't even got to that point yet, and we're simply saying review the words on the page of the permits, which may lead to extra infrastructure or kit. Who knows? That exercise hasn't been done.
Perhaps we'll come to this later. Is the programme of measures required by the 2017 regulations meant to go down to that level of detail?
Well, can I just signpost it there? That isn't an issue for the court, and let me just explain why. First of all, the judge very much parked it, and it's also the issue in a parasitic judicial review, which I'll mention briefly.
Okay.
So at the moment, we're simply concerned, this court, in our understanding, is only concerned with the principle of whether there needs to be, and I emphasise the process elements of this, a water body level review process leading to water body level measures, not at this point with the content of what that might look like, either the outcome of it. That's the level of in one sense, you've been taken down a road of content by the way the issue's been framed, but actually, as I'll show you briefly, the grounds of appeal, very much concerned with the overall process. Regulation 12.6, 12.1, 16.7 are about process as much as anything else. So that's the factual content. You then have, just to pick up a few bits in the Humber Basin River Management Plan itself. You've seen most of this. I'm not going to take the bits you've seen before, I don't think. It's in tab 1 of the supplementary bundle. S1 page 10 tantalisingly says this in the 4th paragraph. The data system allows you to access the data and maps for your river basin district. You can also view this data at a more detailed level. Zooming into the scale that's most meaningful for you, you can view all data for England. And then at 11, under heading 7.2.1 Catchment Data Explorer, the Catchment Data Explorer, which you'll see again in a moment, has allowed people to view and upload or download river basin planning data since 2015. It's also where you can assess the data performance of the plan. The regulations require this data to be presented at river basin district level. The Catchment Data Explorer provides data at this level, as well as allowing users to view it at national catchment and water body scale. So far, so good. That's correct. 13, now we get heading third way down the page, summary programme of measures. The plans contain a summary of the programmes of measures to protect and improve the water environment. In some cases, the detailed and specific on-the-ground actions, exactly what will happen, when and where, have already been identified and agreed. In other cases, the on-the-ground actions will be identified and agreed during the lifetime of the plans. So that's very much signposting what you've seen, which is there may be the odd measure popping up in a plan somewhere, but basically they're pushed out to the future. 27. You've seen the 3rd paragraph, programme measures include on-the-ground actions, for example, improving the sewage treatment works and mechanisms, and that's important. Include on-the-ground actions.
Sorry, which?
So 3rd paragraph on 27.
Thank you.
They include on-the-ground actions, for example, improving the sewage treatment works. That's an example of an on-the-ground action. We say that's the sort of thing that should be there for everything, not just an occasional one. 2 paragraphs further down, the summary programme of measures also describes the main types of on-the-ground action that are delivered through these various mechanisms and signposts to where more detail for specific local measures and actions can be found, where the detail is yet to be delivered, ... So it's rather tantalising because it gives you the impression there is more detail, and there might be some more detail for some water bodies, but it's the incompleteness and obviously nothing for UCB, which is the association's concern. Then at 77, I won't take you through the rest of the bulk of that, you've seen it all.
Right, so 77.
77. You see the top section of that page. If I can take you to below the lower hole punch, paragraph which says this: it is unlikely that existing funded measures and new initiatives currently in development will be sufficient to achieve all the environmental objectives of the river basin management plans. New measurements could include that you'll see that language echoed in the ministerial decision in due course. The simple problem is that in this plan and across the plans as a whole, there is an acceptance that the measures are unlikely to achieve what we say the directive requires at an outcomes level.
Those are funded measures and those currently in development.
And then the rest is possible.
Which refer to identified.
Exactly. Other things may come along, who knows? But also, just to signpost a point I'm going to make in a few minutes, if we're talking about, there's been a lot of discussion about YNEP and Ofwat and so on. That, of course, only applies to sewage treatment works that are operated, I mean, that only applies to sewage treatment works, full stop, but it only applies to those that are operated by water companies. As it happens in the instance here, at least 2 of the point sources involved are nothing to do with that. One is a fish farm and one is a private sewage treatment works. So nothing to do with the YNEP process.
Right.
You then have the famous spreadsheets, and I'm not going to ask the court to open them We understand they are the same across the country, even though they may have some measures that are local within them. We understand they may mention some water bodies, but that is not in any sense an answer to the proposition that's before the court, which is the requirement, as we say it is and as the judge agreed, that the reviews and the measures need to be at water body level. Of course, they can be at a bigger level. Some measures will be. A rule that prohibits farmers behaving in a certain way might be a national rule, that's a measure. But when it comes to a point source, as here, what is required, we say, are mechanisms that are specific, if the point source is identified as being at the cause of the problem, to that process. And this spreadsheet at 176, even blown up, comes nowhere close to that, and this is the best we get for the Humber Basin River Management Plan.
Yesterday, Mr. Kimball introduced the terms point source and diffuse sources.
Yes.
We didn't hear much on diffuse sources. Could we have a definition of a point source? In what sense are you referring to a point source?
So a point source is something like a sewage treatment works or
Is it a term of art?
it's a term of art, yes.
Well, I think we probably have a
And
definition.
I think you may have
already.
it in the glossary of the OEP, but I can check
It
that.
would be useful. And then what is a diffuse source?
Diffuse source would be, for example, farmers. So farmers might be spreading manure on their fields across a county. The effect of that is that there's excess phosphate being washed into the river. So you're not saying
It
it's
doesn't
coming,
arrive in the river at a particular point. It's more diffuse.
it's washed off the fields. Nor can you say it's come from that
Runoff.
particular, it's not come from that particular plant or facility or whatever. So diffuse sources are not subject to the EPR regime. The EPR regime is, in this instance, is catching point sources.
Yeah, I mean, a diffuse source is emphasis on source, as it were, rather than receiver, but
Yes.
perhaps.
It's still the product, in my example, of lots of individual farmers' activities, to use my example.
Yes, yeah, but it's the concept of source that we need to keep in mind. Yeah.
I'm not sure anything turns on that, but obviously we'll
No, but it's just really to understand what the difference is.
It's useful to gather this information and not to have to ask for it afterwards.
Of course. My lords, can I then just take you to the tab 2, which is the Catchment Data Explorer up at the back.
Sorry, page.
Tab 2, page 156.
Thank you very much.
Just a couple of things in there, you've seen much of it. But the overall observation is that what you see here, and you saw it in the table at 158, the RNAG, the reasons for not achieving good table, and then the fish-specific RNAG table at 163, is that the process that he's gone through does indeed look at individual sources of the problem. So these are identified as contributing to the problem at Upper Costa Beck. So there is a granular, very granular exercise gone through. And what you'll see, if I look, for example, at page 163, if you look down the second column, 2/3 of the way down the column, number 44 is point source, and the next one, number 22, is point source. And then I look facing page 164, point source, there. Those are the 4 point sources. So a sewage treatment works, a fish farm, and so on. Identified facilities, acknowledged by the Secretary of State, this is paragraph 14.
I mean, point source sounds as if there is a discharge pipe.
Yes.
As
Yeah.
opposed to, for example, the second row quarry,
Yes.
which is described as diffuse, which is runoff, perhaps.
Whatever it may be, yes.
Okay.
Yes, a discharge pipe is a good colloquial way of putting it, yes.
Yeah, or transport drainage, for example.
Yeah. So the club asserts, and the Secretary of State accepts, that these 4 point sources are contributing to the failure to achieve the objectives in the Water Framework Directive. That work is done at that granular level within the water body in that way. And indeed, as you were shown, there's then, you follow the hypertext link in the left-hand column in each case, you find a page for each of those facilities. So for example, if you look at page 168, that's number 522. That's a facility. We can find a permit for that. We can assert that the permit's deficient. Confirm, you see, in the left-hand column 3 down, even the agency accepts that that's a contributor to the failure. But what there isn't anywhere there is a statement of what measure was taken or was planned to be taken in the previous RBMP cycle, nor is there an assessment of whether that measure has helped, nor flowing on from that then is there a statement of what further measure is going to be taken to address that continuing failure. And each of those things flows out of the statutory framework and the regulations, as I'll show you shortly. And as I say, it's no help to be told there's a YNEP regime, because the YNEP regime may or may not help with the water company's sewage treatment works. It has no bearing whatsoever on the fish farm or the private sewage treatment works, which is not an insubstantial sewage treatment works. It comes off a major leisure park. The other thing just on this document, my Lord Justice Holgate touched on the bottom section on page 159, the classification point. Issues flow out of the fact that this is a heavily modified water body. We're not concerned with the details of that because it's not said that that makes any difference to the answer to the question about measures. But just to give you a reference, it's in Mr. Chandler. This is tab 8, page 248, paragraph 87, explaining that notwithstanding what you see in that wordy text there, the agency is still required by Article 4 effectively to achieve more. They are still expected by the legislative framework to act on the fish. I'm trying to be as neutral as I can. There's a dispute about his analysis, but there's no dispute. There's no suggestion here that there's something about this situation that means job done for Upper Costa Beck on fish.
Can I just check that reference?
Of course you can.
You said tab 8,
Tab 8, page 248.
in the same bundle.
Same bundle,
Is,
yes.
Isn't that Mr. Scott rather?
Oh, sorry, did I say?
You said Mr.
Oh, I said
Scott.
Mr. Chandler. So, Mr. Scott, you're absolutely
It's
right.
Mr. Scott,
Sorry,
yeah.
that's absolutely right.
It's Mr. Scott's second
Scott
witness.
too.
Yes, it's paragraph 87.
Yeah.
Although the fish are not expected to achieve, he says. What he said is the detail is disputed, but the read the last 5 lines. This is why the agency's team are continuing to work to understand why water quality pressures impacting on fish with the aim of putting in place measures to address those problems. There's no suggestion that this is all being sorted out somehow.
By definition, one assumes
Yeah.
that must mean whatever those measures are, one would never find them in the programme.
Exactly. Yeah. Just to correct a minor terminological, if you like, error that the judge made. The tables, the various tables, I showed you one at 168, have got a box that says measure. The judge took the NA as meaning not applicable. Apparently it actually means not available. But either way round, it's evidencing the whole that we say is in this product.
So NA means
Available.
not available, not applicable.
That's at page.
I think the NA appears in everywhere, doesn't it?
Yes,
Yes.
I was, for example, 16.
168, bottom left-hand corner, the way the word measure appears. And we're not taking a point about the format of the document,
No.
but the
If it's easy, but not if it's not, where does the judge make that error?
sorry, I haven't got the reference to hand.
The error. That misunderstanding. Doesn't matter if you can't find it. We'll find it.
67, I'm told. I'm gratefully told.
Okay,
Mr.
thank you,
Fraser.
Mr. Fraser, for that. 67. Yeah, i.e. not applicable. Well, that's. Yeah, got it.
And not available is even more telling from our point of view, obviously. Where that leads you to, you haven't seen this document, I don't think, is that those documents, so not the CDE, but the RBMP materials of which you've seen some, were all provided along with the others to the Minister You've got the ministerial submission and then the sign off. Can I just very briefly take you to that? It's at the back of bundle tab 9, page 265 and following. Paragraph, so the judge quotes, I think 9, 11 and 15.
I've completely lost where we're supposed to be.
Page, it's page 265.
Let's start with which bundle?
That same bundle, supplementary bundle.
Supplementary bundle, page 265.
265.
My page 265 is, oh yeah, thank you very much.
Paragraphs.
So 9, 11 and 15 are the ones that the judge quotes.
So this document is,
This is the covering ministerial submission, under cover of which all the RBMPs were sent to the minister by, I mean, not by the agency, but from the agency to be signed off. So this in effect is presaging, you'll see in a moment, the decision to approve the,
This was a briefing by civil servants within the department,
exactly,
not the EA.
not the EA, yes. So paragraph 9, the updated RBMPs comprise a number of documents and sub-documents. These provide different information for different audiences, from headline information about the pressures on the water environment for the ordinary reader, through to specialised content on what measures need to be taken to improve additional water bodies. That's slightly tantalising.
Individual water bodies.
Because
You said additional.
sorry, individual water bodies. That's slightly tantalising because it might include a little bit of that, but I'm not taking a point on the minister being misled. And then paragraph 11, these RBMPs comprise the final planning cycle envisaged under the Water Framework Directive, in which the deadline for achieving ecological status can be extended, i.e. the end of 2027. So this is the last ditch, as it were. They set out the latest evidence on the state of the water environment, together with the programmes of measures which show how we aim to achieve good ecological status by the end of 2027. They will note that, as is widely known, we have only low confidence that this target can be met by the deadline. So that's picking up what you've seen in the individual Humber plan.
Why does it refer only to good ecological status and not the chemical status?
I don't know. I can't answer that question. But across the piece is an acceptance of we have low confidence that we can meet the deadline. We say on the accepted, and I'll show you why I say this in a moment, view that this is an outcomes focused regime, that is planning to fail. It's not part of the ground of the claim, but the context is, even on the Secretary of State environmental case, the Secretary of State has signed off a document which, if you like, admits a failure. And then paragraph 12, last bit just before we get the redaction, the objectives are therefore set with low confidence that the existing and agreed programme of measures will be sufficient to meet them. So even at the macro programme level that we're told is all important, low confidence of success. 15, given the reference to these mitigating features, we recommend approval of the RBMPs as they are the best product the EA can produce at this stage, both aiming to remain compliant with the underlying legislation and recognising the gap in progress towards 2027. Aiming to remain compliant with the underlying legislation. Hardly bold claim. But that is then, or the Humber version of that is what we then challenge, but that's the decision. You see the ministerial email. Huge amount of redaction, legal implications, and then the ministerial email is on 14th of December, which is page 275. Can I put that bundle away and ask you to turn up then the core bundle?
second. Are we leaving the supplementary
Yes,
for a while?
for a while,
at least?
yes.
Yeah. Thank you.
I'd like me to turn to tab 20, it's statement of facts and grounds. I say that because the arguments so far have somewhat lost sight of the range of the grounds. I just want to remind the court of them. You have at page 543 ground 1, misdirection of law regarding regulation 12.6. Just the first paragraph. Defendant approved the updated plan on the basis of a misdirection of law that review and updating the programme of measures pursuant to regulation 12.6 was not required at a water body level and could somehow be lawfully limited to review and updating at a RBMP or even national level. That's the headline point in ground 1. And that's illuminated. I don't take you through the following paragraphs, but in particular, 61, 62 set out a bit more detail about that. We made the point at 64 that is not undermined by the fact that the RBMP needs only contain a summary of the measures. Well, I think Justice Holgate made the point yesterday, and it's absolutely right, that this whole case has been bedeviled by the Secretary of State and the Environment Agency running together the challenge as if it were a challenge to somehow the plan as feigned to contain the measures. That is not the challenge, it never has been. The judge made that absolutely clear that she understood that. Judge paragraph 108 and 139. The other parties persist in their mischaracterisation of the position, even through these proceedings. I'll skip over ground 2 because that wasn't pursued, but I do want to explain why it wasn't pursued. I'll come back to that. We then have ground 3, which is on page 547. I'll draw your attention in particular to para 73, 77, 78. The HRMBP was not underpinned by a WFD compliant updated programme of measures.
So you're reading from
Paragraph 73, I'm sorry. In breach of regulation 12.1. So 12.6 is about a process. 12.1 is content failure arising from that process.
but it's dependent on one.
Well, the judge is right. We put
Comes down to 1 point.
it can't, but the 1 point has to be understood. So it's about granularity, yes, but it has to be understood in the context not simply of content of plan. This isn't simply about what's in a box. It's also about the process that gets you there,
Ground 1.
which is ground 1.
You're right about the process. You say it affects the content.
Yes, exactly right. As it happened, the judge's analysis could be read as reading it the other way round. But when you look at her judgment as a whole, which we obviously say you have to, you see that she went through each of the processes, the review elements, so 12.6 and so on, and we say correctly took the view that they were themselves water body specific, and therefore it followed that the plan had to be. But you could come to that proposition either way round. But our concern is that the court shouldn't lose sight of the nuance of those multiple aspects of that, because that requires one to look at the totality of the framework and the regulations and not do, as Mr. Kimbling in particular did, is to drill down into a couple of subcomponents and say, well, where in there do we find water body measures? This is about the totality of the regime and its cyclical process working from water bodies up. That's ground 3. Ground 4, page 550, this is complaining of a breach of regulation 16.7. 16.7 is the regulation that allows for the extension of time limits. It implements Article 4.4 of the directive. But what it requires, you see this in the quoted section, paragraph 82, the final bit, underlined, it requires, last 2 lines, a summary of any additional measures necessary for the purposes set out in this paragraph. In other words, if you are going to extend time limits, there are a number of things you have to do. One of them is to set out the measures necessary for that purpose, which we say is necessarily water body specific, because the time limit extension is water body specific, and that's what the judge said. That's regulation 16.
What time limits are we talking about here?
we talk, I'm sorry, Lord.
Which time limits are we talking about here, which are capable of being extended?
In relation to UCB or generally?
Well, in relation, both the UCB.
This was the period leading up to the 2022 plan,
Right.
where the previous plan had received this purpose lawfully, but let's not worry about that. Extended the time limits from 2015 to 2021 it was, but then it was rolled forward to 2022 by COVID. So going to this plan, if they were now going to extend the time limits from 2022 to 2027,
But so I thought the plan was forward-looking,
yes,
therefore we'll be looking to 2027.
yes.
So there's no time limit which can be further extended.
No, but this was extending the time limit in the 2022 plan. We get to 2020, should have been 2021, but we're talking about 2022 plan.
But there is ground for a complaint about a failure to set out measures to deal with that extension of time in that plan.
Yes, yeah, the plan that we're now in, the 2021 to 2027 plan, because it was saying we now need to extend again. We previously extended to say we would do this by 2021, whatever it was. We're now, ignore the 1 year slip for COVID, extending, we're now, for UCB and lots of others, extending to 2027 for UCB. And then the proposition is, having extended, the rules require you, the regulations require you to explain what measures you're now going to put in
is
place.
proposing an extension.
Exactly, proposing an extension and needs to propose measures of how it's going to do it under the now extended time limit.
And the extension applies to what? Every water body?
Every water body, that's what 16.7,
No, but forgive me, as a matter of fact, so far as the plan itself is concerned, for the Humber, say, does it propose to extend the time limit to 2027 for everything?
I can't speak beyond UCB.
There'll be some things which are compliant.
I can't speak beyond UCB, but
But your point is that insofar as it does propose an extension for water bodies, then this regulation would apply to each and every one of those.
Exactly. And that's what the judge found. And for each and every one of those, because the water body extensions are water body specific, because the objectives are water body specific.
So the measures therefore must sensibly also be water body specific.
Lord, I'm sorry.
You say, as a result of what you've just submitted, that also means the measures must be water body specific.
Yes, and that's what the judge said. My Lord, the opening words of the quoted section of paragraph 18 there, the deadline by which an environmental objective referred to in regulation 13.2, etc. may be achieved may be extended for the phase achievement of the environmental objectives for a body of water.
Well, there's 6B as well, isn't it? There's got to be a summary of the measures
To bring the body of water, yeah.
progressively. And it says summary measures because, as it happens, this is something which is to go in the river basin management plan.
Yeah. But then 7.
But in any event, there's supposed to be a programme of measures which is being summarised, so the implication would be that that would be in the more detailed document as well.
Yes.
If there's a difference.
Yeah, exactly right, exactly right. And so the judge, for each of the, so the two particular process points here, 12.6 and 16.7, the judge looked at the regulations and the directive and said, and we say rightly, these are water body specific review processes leading to water body specific measure outcomes, see 16.7. Therefore, the programme of measures need to include water body specific measures. And she I'll come to what she says in a second, if I may. Then finally, ground 5, public consultation.
Well, there's an overarching submission, I imagine, here, which is that you've made it actually, I think, and that is that you've got always in this exercise of looking at what an individual regulation means, or says and means, to have in mind a holistic exercise of interpretation, which you say is imperative here.
And it's a process. It's a process leading to some hard outcomes.
Yeah.
Now,
But I mean, you're reading, effectively, you're looking at these necessarily individual provisions, but you're actually saying that when you look at them together as a piece, they tell only one story.
exactly. And I'll show you that. I'll come to the underlying legal instruments in a moment, but just in terms of how the challenge worked. But ground 5 is on page 551.
Right.
And this is regulation 29. and I'll show you the defendant's guidance in a bit on this, but again, it's the same point.
This is live on the appeal, this issue.
Well, it's live on the appeal in that the judge's order is live in the appeal. Therefore, her finding, which I'm going to show you in a second, her conclusion on all the grounds is in theory live on the appeal.
Because this would have been enough on its own, would it, for you to succeed with the claim?
Any one of these would have been enough on its own to succeed.
Yeah. I mean, ground 5 is consultation specifically.
Yes, ground 5. So what the judge said is she said she didn't find for us on the totality of 5.
No.
She basically said if I'm wrong on granularity, I'm going to call it water body.
Well, that's why I'm raising it, but she said that.
Yeah.
Yeah.
And we haven't cross-appealed on the bit that she didn't find.
No. Understood.
Just if I may very briefly to go back to ground 2, which wasn't pursued, but you need to understand why. So ground 2, page 545.
Yeah.
Parasitic, yes, on ground 1. And that's something why it was not pursued at the hearing, but you need to understand the footnote for that. If you need the water body level regulation 12.6 review, which is ground 1, they haven't done one. That's the assertion, and that's unlawful. Now, in terms of their response to that, if you go interested party, environmental detailed grounds of resistance, at page 463 in the same bundle, paragraph 68, I think is ground 2. The argument in ground 2 depends on it being a requirement of regulation 12.6 review and update present. That's not correct for reasons given above. Alternatively, there is such a requirement, it has been complied with at UCB. So their contention in their detailed grounds was, we don't need to, but we have.
Where were you reading from?
On paragraph 68 on 463.
So this is the EA's
Detailed grounds of resistance.
detailed ground of resistance.
Our skeleton in the High Court at page 423, same bundle, paragraphs 51 through 56, explain why that was wrong. There hadn't, in fact, been a water body compliant UCB review. And then at 406, tab 12 in the same bundle.
Page 423, para
51 through 56.
no compliant
We explained that
review for UCB.
yes,
The ground 2 was focused on UCB.
that was focused on UCB. And then in EA skeleton, it's taken obviously chronologically, page 406, paragraphs 46 to 48. The EA no longer pursues this alternative argument. So they withdrew the contention. So it's undisputed that there was no regulation 12.6 UCB level review if one is required. So we didn't pursue the ground because there was nothing to be gained by it. Picking it up then, if I may, just in the judgment, I know the court's familiar with the judgment, but just to signpost it.
Yeah.
Paragraph 128 in the judgment, page 372 of the core bundle.
Yeah.
conclusions, this is the start of the section.
Sorry, can you give the reference again?
It's about page 372, para 128. In my view, the claimant's interpretation of the WFD and the regulations is correct, and the programme of measures must set out the measures which meet the requirements of the regulations. And then 5 lines from the bottom towards the end, she says this: given that area of law, the defendants never got to the stage of exercising a discretion as to what water body specific measures were necessary in respect of UCB. That, in one sense, is the encapsulation of the we've seen.
So that's ground one.
But it's all of them in a sense, because they didn't do the 12.6 exercise leading to a 12.1 compliant measures, and nor did they do the 16.7 exercise. In one sense, it's the judge. She's potentially referring to all of those arguments. Once the correct legal analysis is applied, there may be further dispute over what's required in the water body specific program of measures, but that is not the issue before this court.
Did you mention a parasitic
That's what I'm going
claim?
to come back to.
Yeah.
So she quashed the RBMP insofar as it referred to UCB, but no further, because that's all we'd asked her to do. And as you've seen in her order,
Yes, let's go back to the order, which is tab 9. The appeal is against the order.
if we get the order.
Yeah.
So paragraph 3, essentially you start with, well, so there's a declaration which picks up some, but not all, of her conclusions in the judgment, but that doesn't mean in any sense that the remainder of her judgment and her conclusions and all the grounds don't stand. I'm just about to take you back to that. I'll take you back to that in a moment. But in paragraph 2, 2 elements, a periodic review of the programmes of measures established under Article 11 and Regulation 12 must be undertaken at an individual water body level. So that's, if you like, a nod to ground 1. And that the programmes of measures must be set out, etc. That's, if you like, a nod to ground 3. Now, the fact that it doesn't mention grounds 4 and 5 in the declaration, we say is neither here nor there, because the judge's conclusion on them, we say, is clear. I'll come back to that in a moment. She then, at 3, quashes the plan, but only insofar as it applies to UCB, because that is what that's concerned about. And then she ordered at 4 and 5 the Regulation 12.6 and other processes that she said were necessary, which, as was agreed, hadn't been done.
Have they been done?
They have been done. The club doesn't accept that what's been done is lawful, and that's when I refer to the parasitic judicial review. A judicial review has been commenced against the outcome of that process and is currently stayed, because obviously if the appeal is successful, it may potentially fall away. So that's why the judge's, the bit I showed you, 128, not an issue before the court, is also not before this court. So we are simply concerned with the, my word again, the granularity of the review and the measures and the consultation exercise, not with the next stage of that, which is what that would look like in any particular case. If I might go back to the judgment then. What the judge then did, and I'm not going to grind you through the paragraphs because you've got them, is she looked at each of the processes involved here, both measures to achieve objectives, the Regulation 12.6 review process, the Regulation 16.7 review process, and others, you've got them all set out there, and said these are all processes which are water body specific and lead to water body specific measures. So when she comes to her conclusion,
I'm sorry to pause you and take you back, but if we look at paragraph 3 of the order, page 331, which says that the defendant's decision to approve the HRBMP is quashed insofar as it relates to the programme of measures as it applies to Upper Costa Beck. But are we told anywhere what specifically is the extent of the quashing then?
Well,
In
in
other
a way,
words, which is the tantamount to saying what are the programme of measures as it applies to, what is the programme of measures as it applies to UCB?
well, you've got the programme of measures,
Yeah.
and it doesn't descend to.
Well, that's why I'm asking,
Yes,
I think.
yes. So obviously everybody was in a conundrum here because the challenge was UCB specific, although it raises a wider legal point. The judge quashed it, and what the agency have gone away and done is what they say is compliant with the judge's order. In other words, a 12.6 review leading to 12.1 programme of measures and a 16.7 exercise. Dispute about whether they've done that lawfully,
Yeah.
but
I think I was only asking really as a matter of fact whether there had ever been an identification for the purposes of paragraph 3 of the order, what the programme of measures as it applies to the UCB actually was.
it's not there. There isn't anything there in a sense.
Well, it's only, I suppose you'd say it's only to be inferred from what the Environment Agency subsequently did,
Yes.
but it's not, as it were, part of the judge's order.
No. Because the programme of measures
Yeah,
as it applies is the Humber Basin one,
yes, yes.
which is entirely across
Yeah,
the
no,
piece.
it's just, I was asking a question of
Yes.
fact, I think, really.
I think we may have been, we could have been more creative with the order, the quashing, but that's. I think everybody knew what was expected.
Yeah, I imagine that the judge, perhaps this is clear from something we've got in front of us, the judge said to the parties, please prepare a draft order, and they did.
Mm.
And this was the product of that exercise. I don't know.
I think that's right, my lord.
Trying to understand this, we've seen for UCB point sources, those sheets where the measure was said to be not available. So there's nothing to quash there.
Yes. Well, there's nothing positive to quash.
No,
but
that's the same thing.
Yeah.
But has the assessment carried out in relation to UCB treated all the matters which need to be the subject of measures as equivalent to point sources, or I think you saw some of them were diffuse?
You mean has the
In
subsequent
other words,
process?
is UCB, according to the plan as it currently exists, partly to be dealt with by reference to generic measures?
Well,
Are some of the generic measures in the programme measures relevant to UCB?
they're relevant in that, for example, they include the permitting regime.
That's why I asked the
Yes,
question.
yes. But
I'm wondering what the effect of the order is. I mean, is it just confined to those specific matters which we've seen?
Yes.
Or does it have implications also for the bits of the programme of measures which are generic?
well, it was seeking, and the judge was seeking, and the order was seeking to confine it.
No, you're not. I'm not putting my question very clearly. I'm sorry. I understand that you were confining the relief sought in terms of quashing to UCB, but as I understand, the plan doesn't purport to deal with UCB solely in terms of specific assessments of the kind we saw. I think it's page 168 of the supplementary bundle for a point source, for example. In part, it is relying upon generic measures. So if that's the solution, then some of them are national, it's the permitting regime. So I'm just wondering what the effect of the order is in relation to those matters. It would appear to be quashing the generic measures insofar as they relate to UCB.
I don't think anybody intended or understood it that way.
Well, yeah, but they may not have thought it through.
I don't think.
What I think the answer might be, what's quashed is the River Basin Management Plan,
Yes.
insofar as
Yeah.
it applies to
Yes.
the UCB.
It's not quashing the EPR.
So as a result of the order, there is no approved plan insofar as it relates to the UCB. That's right, isn't it?
Which would cover reliance upon
Yes.
any generic measure
For
insofar
the
as it's...
UCB.
Yes,
Yeah,
that's
for the
UCB.
UCB.
I'm sorry I put it
Yeah.
clumsily.
It's not purporting or attempting to quash.
I mean, the reality of this is that there are implications for third parties, if I can call them that. In other words, parties not involved in this litigation at all.
At UCB, yes.
And potentially wider than UCB.
Yeah.
And that I think is the thrust of my
Yes.
lord's question.
Well, so the
I appreciate you were only concerned about UCB, but we're concerned about the law.
Sure, I understand that, but the rest of the plan, the rest of this plan and all the other plans survive. So for all other water bodies and therefore all other anybody, third parties, if you like, they are unaffected by this. That's the.
Just looking at what we've got to do, we obviously need to go away and consider it all very carefully. Your position, there's no cross appeal here. Your position is to maintain the order as given by the judge.
Yes.
You're not contending for some alternative formulation of
No.
the relief.
But obviously, if the court,
Well, it lies within our discretion in any event, I think.
Yeah.
That may be, I mean, I don't know whether that is ultimately something we might need to consider. I've no idea.
Well, we weren't seeking to trouble you with any.
No, I understand.
Parties have raised that.
Right.
My lord, can I just then? Oh yes, I'm reminded. Paragraph 3. Just those words may be important. The decision to approve the HRBMP, as opposed to necessarily the HRBMP,
Yeah.
Only insofar as it.
only insofar as it relates to that. Yes.
So the decision to approve the HRBMP generally and more widely, excluding the UCB, is
It's
unaffected by
unaffected.
the law.
Yes. Well, in terms of the judgment, so 128 starts the judge's analysis. I'm not going to take you through the individual paragraph, but as I say, it does deal with each and every one, and go back to my Lord Justice Lindblom's point, different elements of the framework. This isn't just jumping in at the end.
Lord Justice Kindlen being which one of the three of us?
I'm sorry, my Lord.
I thought you said Lord Justice Kindlen.
No, Lindblom.
Lindblom, sorry, did I?
I think I heard my name.
I'm glad you did. I exchanged knowing glances with you in the Secretary of State and was a little
I don't think he
And
was
then
the person
that
involved.
leads her to 146. My conclusion on the issue of statutory interpretation deals with grounds 1, 3 and 4, and on ground 5 further, the Constitution further enforce my conclusion on the other grounds. So she finds for us on 1, 3 and 4, and indeed 5, but the complication on 5 is that she doesn't find for us on the, as it were, the common law fallback point outside the regulations, outside the granularity point. The reason I emphasise all that is that both her reasoning and her findings, when you read it by reference to the grounds, deal with a number of threads of things in the legal framework, some of which, Regulation 12.6 and 16.7, are about the process, and that of course feeds into the granularity of the outcome of the process. But we don't want to lose sight, and we invite this court not to lose sight of the nuance of that, the range of issues there. Well, can I then briefly take you to Core Appeal Bundle tab 5, which is the OEP's material. This is the introduction to, I'll come to the legal framework in a bit. Page 95, this is in the OEP submission. We as you see, adopt the OEP submission.
You adopt them in the entirety, do you? Yeah. Page 95, yes.
Paragraph 26.
Yeah.
Here talking about Article 4.4 in conjunction with Article 13.7. We'll come to that, the details of that in a minute. But the overall process of achieving the objectives for each water body, they say, and we agree, and I'm going to show you this in the due course is an obligation of result. This isn't just a process, a toolbox, whatever it may be. It provides, this framework taken as a whole leads to an obligation of result, which is for each water body to achieve the objective by the statutory deadline, unless the derogations allow you to do differently. The Secretary of State responds to that report and those materials in tab 6. You could turn up to page 317, paragraph 14. Line 4. The programme of measures is required to address the objectives. How it does so is ultimately a matter of the Secretary of State. So long as they are reasonably satisfied, it will achieve those objectives.
Can you give me the reference again?
Paragraph 14 on 317.
Yeah, line.
And 4 lines down towards the end. The programme of measures required to address the objectives. How it does so is ultimately for the Secretary of State. So long as they're reasonably satisfied, it will achieve those objectives. We read that as an acceptance of this being an outcome obligation, an obligation of result in the way that the OEP explained it as a response to the OEP. 3 lines further down, 4 lines further down, the same point is made in slightly different words. The emphasis, therefore, is to determine a programme of measures which the SoS judges will, taken overall, achieve the objectives. That's consistent with the OEP's proposition that this is an obligation of result. You see, that's not what the Minister signed off on, because it was low likelihood of achieving the objectives. We say that's inconsistent with the way the Secretary of State now puts the case, which is to fall back, if you like, on the toolbox argument. As long as we've got the tools in the toolbox, that's enough. The next point,
having the tools is not the result.
Exactly.
The use of the tools.
Exactly. How are we going to use the tools to achieve the result by the time? And even if you don't get granular, even if you just look at paragraph 14 on a non-granular basis, you'd say, well, fine, Secretary of State could be satisfied across the piece that the programme of measures will achieve the result without doing it water body level. Query how they could reach that conclusion without doing it water body level unless they signed a blank cheque, but you could in theory do it. But that's an acceptance of the outcomes basis. Just in terms of process, paragraph 22, talking about the process, a distinction should therefore be drawn between a subsequent review of the effectiveness of a programme of measures, that's regulation 12.6, which is necessarily going to include a review of whether environmental objectives have been met at the water body specific level, from the consequential plan to address any identified failures. And again, it seems to be an agreement as to the granularity of the review process. Bulking at the measures step, which we say is where the fault lies. And the EA's response, which you have in the next tab, paragraph 9, page 324, they make the point that Mr. Fraser's made in submissions to say there's a separation between the programme of measures and its subsequent implementation.
Paragraph 9, was it?
Paragraph 9, they say there's two separate things. Over the page, at the point in time of preparing and updating the programme measures, the EA only needs to be satisfied that the programme gives the EA the measures it needs so that it can, when it makes operational, implement the water body level, the EA can aim to achieve the objectives of the water body set deadline. That's the toolbox proposition. That's to some extent where Mr. Kimberlin retreats in his submissions to this court. We say that's completely inconsistent with the obligation of result acceptance by the Secretary of State that I showed you a moment ago. And it begs the question, how can we see where implementation of measures at Upper Costa Beck in previous cycles have achieved the objectives for Upper Costa Beck in previous cycles. If this is all about post-plan implementation, we would expect some post-plan implementation, of which there has been none. You see none. Of course, we say that's wrong in principle when you look at the legal framework. You don't somehow carve out implementation as a post-plan process. That would rob the plan of any, and its underlying programme of measures, of any substance. This is not simply programmatic in that way. You'll see why I use that word in a moment. Can I then go into the legislative history for the Water Framework Directive before going to the directive itself? And first, just look very briefly at the document we were given a better copy of today. I think it's gone in at page 645A.
Right.
This, of course, is a DEFRA document. It's not part of the EU legislative process.
365 or
I think it went in at 645A. It was
645 and 645A.
That's right.
645 is where I needed to be then.
Tab 20.
Obviously, no one can place much reliance on this because of its status, but in paragraph 5, about 5 lines from the bottom, 6 lines from the bottom towards the very end, it says this: the competent authorities would also be responsible for drawing up, consulting on and then implementing management plans for each district containing programmes of measures designed to achieve the environmental objectives for the waters in each basin. Not the clearest of wording, but we say that's exactly.
I'm so sorry, my fault. Where were you reading from exactly?
From the last bit of paragraph 5.
Oh, sorry, I was on the wrong page. Yeah, thank you for that.
Starts the competent, it's the end of the line.
Yeah.
Next bit of legislative history.
Before you go away from there, the next sentence says such plans will be enforced by the end of, let's skip over the date, with all the measures operational.
Yes.
So that suggests that measures should be actions or steps to be taken.
Yes, yes. You were also shown, for the purposes of legislative history, document at tab 19 of the authorities bundle. And I just go to that document at page 626. If one is going to place reliance on this document outside what we see in a moment from the ECJ, halfway down 626, above the bullet point list, perhaps the clearest issue which emerges is that there is a need for greater integration in the practical implementation of water legislation. Integration is required between, and there's a list of things. Commission believe that this can be improved through adoption of a framework directive which would require integrated water management plans. The plans would contain an assessment of the overall situation in the water body, including its environmental quality, its resource potential, and the environmental pressures impacting on it. It would also establish the specific objectives of water policy in relation to that body of water and a programme of measures designed to achieve those objectives within a specified timetable. And as it happens, that and other travaux préparatoires were looked at by the Advocate General and from that the court in the Vesser case, which you have the AG at tab 13.
Fraser.
The situation here, the concern here was a development consent proposal in effect for the river, which would affect its Water Framework Directive objectives. So the question was, do we have to refuse project consent? But nonetheless, unsurprisingly, the AG and the court looked at the Water Framework Directive in a wider sense. In the AG, can I just draw your attention to paragraph 34?
That's at page.
Page 902. Oh, I'm sorry, it's 415. I'm sorry, I'm getting the wrong page numbers. 415.
That's 415.
But the
The
alternative
smaller,
pagination is 902, yeah.
that last sentence of paragraph 34. Then furthermore, the Netherlands government submits that the WFD lays down a programmatic approach in that it gives the member states wide flexibility as regards its implementation. Programmatic response, you've heard the language of strategic framework, is essentially what the Secretary of State now argues to this court. This is not about a result, this is about tools in the toolbox and a programmatic approach. 34. You then at 49.
I think the two governments were taking different positions, weren't they?
Yes.
Yeah. 49.
Must establish programs of measures. The program is a tool for responding to the identified pressures, thus enabling the river basin or body of water to reach good status. Such programs may make reference to, and then the AG sets out elements of 11.3. And 52. Next, the programs of measures are incorporated into the management plans. And then 6 lines from the bottom, middle of the line. That is clear from points 5 and 7 of Annex 7, the directive, which state that a management plan is to include a list of environmental objectives and a summary of the programme of measures, including the way in which those objectives are therefore to be achieved. At the end of that laborious process, member states are required to implement the measures laid down.
Well, you say that again implies that measures are practical steps.
Measures are practical steps at water body level, and they are implemented within, there's no separate process of implementation during which you work out what your measures are. You formulate the measures in the programme of measures, which is summarised in the plan, and then...
This sounds like we're getting into the parasitic judicial review.
Well, I don't intend it to.
No, but I mean, I've been sitting here wondering when you're going to tell us what a measure is, and it's one thing to call it an action on the ground, but that raises the question, how specific is the action?
And for these...
In the programme of measures.
Yes. And all we say is that the 12.6 review needs to focus at a water body level to generate conclusions which are legally capable of being measures at a water body level that are specific to the water body. As to what that looks like, that wasn't the judge deliberately, I don't know, deliberately is the wrong word, didn't descend into that level of detail and specifically identify that that was an issue for another day.
So this is the AG speaking.
This is the AG. You then get the ECJ at tab 14. The question starts at paragraph 29. Page 438 in small numbers. And then at 37, accordingly, the ultimate objective of the directive is to achieve, by coordinated actions, good status of all EU waters by 2015, is to achieve. This is not just a programmatic.
And that's your objective of result.
Exactly. And then 42, in order to ensure the member states attain the objectives referred to above, the directive lays down a series of provisions, in particular articles 3, 5, 8, 11, 13, Annex 5, establishing, as the Advocate General has noted in paragraphs 43 to 52 in his opinion, a complex process involving a number of extensively regulated stages for the purpose of enabling the member states to implement the necessary measures on the basis of specific features and characteristics of the bodies of water identified in their territories. And then these matters confirm the interpretation of Article 4.1a does not simply set out in programmatic terms mere management planning objectives, but has binding effects once the ecological status of the body of water concerned has been determined at each stage of the procedure. So it's not merely programmatic, it's obligations of result and water body level. Can I then go to the directive itself? Which you have in tab 1. And first, if I may, to the recitals, I'm not going to grind you through each of them. You were referred to recital number 13. Decisions, 45 lines down, decisions should be taken as close as possible to the locations where water is effectively used. Priority should be given to action within the responsibility of member states through the drawing up of programmes of measures adjusted to regional and local conditions. Of course, none of these is determinative of the question that we're answering. They're all shining a light on it, though. We say local conditions, therefore, there includes water body level. This isn't about districts or river basins. And 14 picks up consultation effectively. The success of this directive relies on close cooperation and coherent action at community, member state and local level, as well as information, consultation, involvement of the public, including users. If all we're being asked about is the fitness for purpose of the EPR, that's hardly local consultation of the kind contemplated there. 18, community water policy requires a transparent, effective and coherent legislative framework. The community should provide common principles and the overall framework for action. This is about action. (26) Member states should aim to achieve the objective of at least good water status by defining and implementing the necessary measures with integrated programmes of measures taking into account existing community requirements. Now, that objective of good water status is water body level specific. Objectives are only set under the directive at water body level. Then 31, in cases where a body of water is so affected by human activity, its natural condition is such that it may be unfeasible or unreasonably expensive to achieve good status, less stringent environmental objectives may be set. What we see throughout is that there are references to objectives. They are all necessarily references to water body level objectives. 33, the objective of achieving good water status should be pursued for each river basin, but the objectives necessary water body level, so that measures in respect of surface water and groundwater belonging to the same ecological, hydrological and hydrological system are coordinated. So you have measures at water body level which you coordinate at 35. Within a river basin where use of water may have transboundary effects, the requirement for the achievement of the environmental objectives should be coordinated. Again, necessarily water body level objectives. 36. It's necessary to undertake analyses of the characteristics of the river basin and the impacts of human activity, as well as an economic analysis of water use. The development in water states should be monitored by member states on a systematic and comparable basis throughout the community. This information is necessary in order to provide a sound basis for member states to develop a programme of measures aimed at achieving the objectives established under this directive. Objectives again, water body level. And then finally, 45, 46, 45. Member states should adopt measures to eliminate pollution of surface water by priority substances and progressively reduce pollution by other substances which would otherwise prevent member states from achieving the objectives for the bodies of surface water. So adopt measures by reference to objectives for bodies of surface water, all of a piece. And 46, finally we return to public involvement. To ensure the participation of the general public, including users of water, in the establishment and updating of river basin management plans, it's necessary to provide proper information of planned measures and to report on progress with their implementation with a review to the involvement of the general public before final decisions on the necessary measures are adopted. That goes bang into the club's concerns about consultation and is, we say, necessarily and obviously at a water body level. Then into the body of the directive, you've been taken to very few provisions of it. It does, as the AG and the ECJ said, have to be read as recognising a complicated interaction. Article 3, page 15, 3.4, Member States shall ensure that the requirements of this directive for the achievement of the environmental objectives established under Article 4, and in particular all programmes and measures, are coordinated for the whole River Basin district. Two things. First of all, it necessarily follows from that programmes and measures are sub-RBNP level. But more importantly, it goes bang into the outcome requirement. The requirements for the achievement of the objectives established in Article 4, etc., are coordinated. The requirement for the achievement of the objectives, they are water body level specific objectives under Article 4. So we then get to Article 4 itself. The words "in making operational" simply do not, particularly when you read it in the context of the rest of the directive, have the effect that the Environment Agency and belatedly the Secretary of State would have it, that this somehow isolates the identification of the measures to some post-RBNP process. It is simply making
the object of the action.
Exactly. It's simply drawing together, when you read it with Article 3, 4, and we'll come and sense to other things in a moment, measures are not things that sit on the table. They are the things that have to be implemented to achieve the outcomes individually and collectively across the water body. We then have, for surface waters, look at 4.1a.3, which is at the top of page 17, because that's the heavily modified one, but there's others similar effect. Protect and enhance all artificial and heavily modified water bodies with the aim of achieving good ecological potential and good surface water chemical potential at least 15 years from the date of entry from this directive.
I'm sorry, you're reading from?
4.1a.3, which is the top of paragraph, page 17.
Sorry, yes, I've got it.
That's the 15-year that was subject to extensions. In accordance with the provisions laid down in Annex 5, subject the application of extension determined in accordance with paragraph 4 and the applications of paragraphs 5, 6, 7, applications to 8. That's where you get the derogations all bundled together. And then you get 4.4. Time limits may be extended for the phased achievement of the objectives for bodies of water. It's a body of water specific process, provided no further deterioration occurs in the status of the body when all of the following conditions are met. You'll see if one needs comfort. The last sub-Roman 2 at the foot of the page, there's a cost safety valve.
Cost safety valve
is in 4A, there's a Roman 2 at the foot of the page, disproportionately expensive.
Yeah, so is that a, how wide does that go actually? I mean, we were treated to some, as they were described, eye-watering amounts of money yesterday in the submissions.
So what this allows the plan maker to do,
Yeah.
either in relation, I'm here talking about time extensions, but we'll come in a moment to reduced aspiration, to say, and I paraphrase, and it's a crude paraphrase, it's not worth it, disproportionately expensive, but please don't take my crude paraphrase because this is
No.
complicated law. But the eye-watering figures, you
Yes.
have to be seen in the context of a framework which is not a blank check framework. Then,
Well, just reading this as a whole, the opening words of 4, objectives for the bodies of water, you say is water body specific. But a purposive reason as to why that might be the case is that why on earth should time limits be extended where there's no need to extend them?
yeah.
You would only extend the time limits specifically in relation to water bodies where that's needed.
Yeah.
And then if that be the right way of reading 4, Roman 2 is contemplating a cost-benefit analysis, which is case-specific.
Yes. And that was right. And and you get the same answer with reduced aspiration, which will less stringent environmental objectives. It's a similar framework. Just carry on in the time extensions point. For 4B, top of page 19, you have to set out extension of the deadline and the reasons for it are specifically set out and explained in the RBMP per Article 13.
That means setting out something more than just repeating the words of the directive.
Yes. But that's not this.
Like we've seen the comments, disproportionately expensive.
Yes. It's not an issue in this case, but that doesn't look like a very thorough analysis for the purpose of these extensions. But it's not an issue in this case. And then C, extensions shall be limited to a maximum of 2 further updates, except in cases where natural conditions are
So
such that.
going back to Roman 1, the scale of improvements required can be achieved in phases exceeding the timescale.
Yeah.
I mean, you may or may not rely upon that.
Yeah.
If you do, you've got to have something contemplated in enabling you to say, well, this will exceed the timescale because of the nature of the improvement.
Yeah, exactly. And then C, 2 further updates, so that gets.
See Roman 3. How come I talk about natural conditions generically?
Yes.
They will vary from site to site.
Of course they will, exactly, yes. Extensions for a maximum of 2 further updates, so that gets you 15 plus 12. Gets you to 2027. That's
Indeed, I'm sorry to be slow, but Roman 3 specifically says the body of water.
Yes. And then D, a summary of the measures required under Article 11, which are envisaged as necessary to bring the body of water progressively to the required stage by the extended deadline. The reasons for any significant delay making these measures operational and the expected timetable for their implementation are set out in the RBMP. A review of the implementation of those measures and a summary of the additional measures should be included in updates to the RBMP. We'll come to 11 in a moment, but again, this is water body level specific measures relating to water body as part of your praying in aid this derogation of additional time. And then 4.5 deals with less stringent environmental objectives. Not in dispute here, but has a similar sort of framework to it. Then we go to Article 5.1. Each member state shall ensure for each river basin district or a portion of each international river basin district in its territory an analysis of its characteristics, a review of the impact of human activity and an economic analysis of water use is undertaken according to the technical specifications set out in Annexes 2 and 3, and that's completed at least latest 4 years after the date of entry into the force of this directive. I'll show you Annex 2 in a second. This is a water body level assessment of the status of the water body and of the either called reasons for failure, RFF, or RNAG, you've seen reasons for not achieving good. That's a particular status. And you'll see this in a second, of the measures needed to deal with that. I'll show the annex in a second. The analyses and reviews mentioned under paragraph 1 shall be reviewed and, if necessary, updated at least 13 years after the date of the force directive and every 6 years thereafter. 13 years from 2000 gets you to 2013, 6 years after gets you to 2019. That is why Mr. Kelton was writing in 2020, 2021 to say, where is this exercise? Where is your, he used the word gap analysis, you'll see where I get that in a moment, because that should have been the entry point, the foothills of the process which led to the RBMP. Because the RBMP cycle actually starts with, but includes this review, which should have started in 2004, and is then repeated each cycle. If I go to Annex 2, you have this at page 44. Diving in at paragraph 1.4, you'll see why in a bit, because I show you some CIS guidance that applies to these paragraphs. Excuse me. 1.4 in Annex 2, page 44, identification of pressures. And then 1.5, assessment of impact. Member States shall carry out an assessment of the susceptibility of the surface water states of bodies to the pressures identified above. Member States shall use the information collected above and any other relevant information, including existing environmental monitoring data, to carry out an assessment of the likelihood that surface water bodies within the River Basin Management District will fail to meet the environmental quality objectives set for the bodies under Article 4. Member States may utilise modelling techniques to assist in such an assessment. So this is a water body specific assessment of the likelihood of failure, which was done in 2004 and is then cyclically updated. But those bodies identified of being at risk of failing the environmental quality objectives, which all these are, further characterisation shall, where relevant, be carried out to optimise the design of both the monitoring programme required under Article 8 and the programme of measures required under Article 11. So the programme of measures, directly water body specific, comes out of this cyclical evaluation process in the foothills of the process leading to the RBMP. Feeds directly into the Article 11, which we'll see in a moment. That's why Mr. Kelton was writing back in 2019, after 2019. But from that, that takes us back into Article 11. So we see that the programme of measures in Article 11 has come out of that water body specific cyclical process, which is running 2 years ahead of the RBMP process. So Article 11 doesn't come out of nowhere. Article 11.1, each member state shall ensure the establishment for each river basin district or part of an international river basin district of a programme of measures taking account of the results of the analyses required under Article 5 in order to achieve the objectives established under Article 4. So the process feeds into the programme of measures in order to achieve the objectives. Such programmes of measures may make reference to measures following from legislation adopted at national level and covering the whole territory, where appropriate, a member state may adopt measures applicable to all river basin districts or a proportion of international river basin districts within its territory. So you can have a rule that applies to all farmers and says don't spread too much manure on your fields. That's perfectly permissible. But what we say you need to be able to say is what's in place to deal with the particular pressures at, in this case, UCB. Then you've seen all this. Each programme of measures shall include the basic measures, supplementary measures. Can I just divert you for a moment by reference to 11.3a? I want to do that? No, I won't do that. Can I just drop you to the basic measures? You've seen all this. I won't take you back to it in detail. 11.3g, though, is important.
Well, I was looking at C. In order to avoid compromising the achievement of the objectives specified. It's the same point again that you've been observing.
That's the water body level.
It's got to be related to the water body objectives.
Yeah. You can't get away from that everywhere you get. Look. For point sources liable to cause pollution, a requirement for prior regulation, such as prohibition of the entry of all pollutants, or for prior authorisation or registration based on general binding rules laying down emission controls for pollutants concerned, including controls in accordance with Articles 10 and 8.
10 and 16.
10 and 16, I'm sorry. Just pausing for a second there. You can do it in different ways. England has chosen to do it by, amongst other things, the EPR, and in relation to UCB has chosen to do it by putting in place EPR permits for the point sources which you've heard mentioned. Perfectly proper, implemented basic measures to that extent. Next words are important. These controls shall be periodically reviewed and where necessary updated. Now, not a transposition error, but those closing words do not make it into the regulation 12 equivalent of that paragraph. Not a problem, because regulation 3.1 requires all the relevant people to act to secure the objectives of the directive. But that periodic review obligation is not simply about standing back every now and then and saying the EPR regime is a good regime. It's about reviewing the controls that in this instance have been put in place in relation to the point sources at UCB, etc. Then we have 11.4, the supplementary measures with the aim of achieving the objectives established pursuant to Article 4. So you've got the basic measures, which are more legalistic. Part B of Annex 6 contains a non-exclusive list of such measures. So could we just momentarily look at Part B of Annex 6? It's on page 86. You see the breadth of the sorts of things that can be involved there. Educational projects you were shown. If you run down the list, Roman numerals 11 and 12, construction projects, desalination plants, and so on. These measures are absolutely specific implementation examples. They're not legislative frameworks. The measures can, and if necessary, should include particular a desalination plant, something new on a waste treatment water works, whatever it may be.
Just looking for the page.
Absolutely.
It's page 86.
86, sorry, I'm in the wrong page.
So we looked yesterday.
Yes,
at the
we
fact
did.
that Part 1 doesn't apply. That's neither here nor there, because that's the
I think it's part A, isn't it?
Part A is disapplied.
Not part
Doesn't
1.
apply. Part B, you get. But again, this is the aim of achieving the objectives. Again, water body specific objectives. Then 11.5. This is the analogue of regulation, covenants of regulation 25. Where monitoring or other data indicate that the objectives set under Article 4 for the body of water are unlikely to be achieved, couldn't be more specific as being body of water. Bullet point 4, additional measures as may be necessary to achieve those objectives are established, including as appropriate the establishment of stricter environmental quality standards following procedure laid down in Annex 5. That is absolutely clearly bang on water body specific measures. The judge reached that conclusion. Measures there must mean, she said, water body specific measures. And she then looked at 11.8 over the page. The programmes of measures shall be reviewed and, if necessary, updated at least 15 years after date of entry into force of this directive and every 6 years after. Any new or revised measures established under updated programmes shall be made operational within 3 years of their establishment. That's the 12.6 obligation that is fixed on by ground 1. And the judge said, and we say she's absolutely right, that the measures there in 11.8 has to be the same as the measures in 11.5. There's no basis to construe them differently. And 11.5 is clear as clear, water body specific. So she says this must be 2, and indeed that makes sense within the framework of the rest of the directive. Any new or revised measures have to be made operational within 3 years. That's about working out in the plan and the underlying programme of measures what you're going to do to deal with these problems, water body by water body.
Can I just appreciate, we've got a little time left. How are we getting on with time?
Pretty well, I think.
When do you think you're likely to finish your submissions?
About 20 minutes or so, is that okay?
Mr. Kimberlin, how long is your reply likely to be?
I think that cloth will be cut accordingly.
Right. Well, I think Thank you very much.
I can speed up if you need me to.
No, I'm not asking you to speed up. I think it may be that you can take some of it in shorthand fashion, just by giving us references. But I think we'll hold you to 20 to 1, if we may, please.
Well done, Graham, grateful. So 11.8 is the analogue of 12.6, and that was ground 1. Then you get the RBMPs, that's Article 13. RBMP, this is 13.4, has to include the information at Annex 7. I'll come to that in a moment. And then 13.7 gives you the cyclical nature of RBMPs. 14 is the public information and consultation proposition, which, yes, it requires consultation on the RBMP, but over the page, after C, on request, access should be given to background documents and information used for the basin management plans. So you don't have to put them in place, although you'll see the regulations do exactly that, they put them in the public domain. You've then got Annex 7. I can go to that, please. That is the structure of the RBMPs. You've seen most of it. Within Annex 7, 7 is the summary of the programme of measures. Must be something underlying the summary. Then over the page at 8, A8, a register of any more detailed programmes, dealing with sub-basins, etc. And then 11, the contact points and procedures for obtaining the background documentation and information related to an Article 14.1, and in particular, details of the control measures adopted in accordance with Article 11.3g and 11.3.1 and the actual monitoring data gathered in accordance with Article 8 and Annex 5. So that review that I showed you in Annex 3G, the outcome of that review has to be available to the public in that way. Then we get the regulations. I mentioned regulation, this is in tab 2, regulation 3.1. The overall obligation to exercise their functions to comply with the directive. So any gaps in the implementation are filled in by that. Then regulation 12. So 12.1 is, as you've seen, ground 3. 12.6 is ground 1. The appropriate authority must ensure for each river basin district the environmental objectives and programme measures are periodically reviewed and appropriately updated, and then there's a time cycle. And the 2021 date is what slipped to 2022 by application of COVID. So it's that failure to review the programme of measures which we say needs to be water quality specific, which was the proposition there. You've then got 16, so this is ground 4, and 16.7 in particular. Following extension of paragraph 1, the next update must include a review of the implementation of the measures referred to in paragraph 6.3b and a summary of additional measures necessary for the purpose of that paragraph. Again, water body specific measures required or consideration of them for the purposes of that extension. 20, content of measures. 22G, 20 sub 2 sub G, point I made before, point sources discharge levels cause pollution, a requirement for prior regulation or prior authorisation which sets emission controls for pollutants concerned. That's the bit that didn't include those additional words, they must be periodically reviewed. Presumably because thought of that goes somewhere else anyway. (12.4) programme of measures. Where necessary, each programme of measures must include any other supplementary measures designed and implemented with the aim of achieving the environmental objectives under Regulation 12. So measures and objectives must be water body specific.
Sorry, which regulation were you?
12.4, sorry, 20 sub 4, I'm sorry.
24, yes. 20 sub 4.
You've got 25, which is the implementation of Article 11.5, the one where the judge said this is very clearly, obviously, water body specific. You've got Reg 27, which is RBMP content, and 27.2D. You see that brings in Annex 7, parts A and B. Showed you that before. You've got Regulation 29, public participation. So this is ground 5. Publishing notice and so on. You've got Regulation 31, which is the 31.4 is the approval, or 31 is the approval. So that's in effect a decision which is under challenge. You've got 32, which is supplementary plans. We say that doesn't at all answer the question of water body measure at specific levels. Then you've got 34, which is a public information point, which I think flows from Annex 7. Publication of information. The appropriate agency must make accessible to the public and its principal office, 34.1e, the environmental objectives and programmes of measures proposed and approved under Regulation 12, environmental objectives and programmes of measures. And we say that's necessarily water body specific, not in the plan, but available from the office. So that's the regulations. Secretary of State's guidance, tab 17.
Just so we're clear about regulations in full, that's in part 7. You can see that from page 142, part 7 general publication of information, it's not part 6.
Yeah.
So this applies inside
Generally.
and out. Generally.
Yes, it's not RBMP, yeah, exactly right. Secretary of State's guidance, September 2021. We say supported entirely of us, judge saw it the same way. So, page 512, paragraph 5.2.
Sorry, just pause for a second. We're in which bundle?
Tab 17, you may have a separate volume, I'm not sure if you've been split, I think.
Tab 17. Of the
Authorities?
authorities.
Sorry.
It's in volume 1 now. Yes, sorry.
Paragraph 5.2, iteration is built into the process. Fourth bullet, in the light of this, reassess the objectives and consider the useful alternative objectives to determine the measures that will be implemented in the period covered by the plan. Absolutely water body specific. Then you've got on page 518, under the heading consultation, paragraph 8.7, 8.8, the consultation should propose environmental objectives for each water body in the river district and programmes of measures to achieve those objectives. That's the Secretary of State saying to the EA, the consultation has to improve programmes of measures at water body level, we say.
Which paragraph is that?
8.8, page 518. Then you've got 520, 9.1 and 9.2. I think my Lord may have asked why the Secretary of State hadn't withdrawn this guidance. Of course, this guidance is now actually states the law correctly as stated by the judge. There's no reason to withdraw the guidance. The prior question, though, is why did the Secretary of State sign off plans apparently based on a version of the law which isn't what his guidance set out? So we didn't take a point about the plans not complying with the guidance because we had better points. But on the face of it...
No, I was simply following through on the concession made about...
Well, I'm not sure it's a concession in a sense.
Well, right, let's put it differently on the observation made about...
So we say that's entirely on our side, and the judge said so. You've also got page 538. Paragraph 14, programmes of measures. WFD regulations refer to both actions and the delivery mechanisms as measures. So actions and delivery mechanisms. This guidance the terms used as follows. Measures is used to mean any action which will be taken on the ground to achieve the objectives. Absolutely water body specific. 14.3, programme of measures must include all the measures necessary to meet all the objectives that are for a basin district, including protected areas, and measure the aim of progressively reducing pollution and so on. Again, necessarily water body specific. (1419), Secretary of State doesn't want to see all the detail, fair enough. 14. Right, that's that document. The Commission materials, similarly, the CIS documents, you have at tab 22. At 691 is the start of a section which is talking about the Article 5 analysis process. At 696, it introduces something called the DPSIR framework, and there's a table, water body by water body, response to the measures taken to improve the safety of water, e.g. restricting abstraction, limiting point source discharge, developing best practice guidance for agriculture. That cyclical DPSIR process.
I know we were on 696, but I'm afraid I didn't follow what.
It's the table, my lord. It's the table 2.2.
Ah, table 2.2.
There's the DPSIR. I'm sorry, it's my haste. This is water body by water body for the Article 5 process. Work out the response, which is measure by measure. And then at 698, top of the page, under 2.3.1, the requirements described above all relate to a body of surface water or a body of groundwater. And that DPSIR framework.
698? Oh, the first sentence.
First sentence.
Yeah.
That is what the drafts of this material says you should do the Annex 5, sorry, the Annex 2 process, Article 5, Annex 2 process. And as it happens, that DPSIR framework is then explained and adopted by the OEP. If I can just give you page numbers for this, it's C5 154, 236, 239, and 240. The OEP treats that as being useful as illumination on the process. Then you have in tab 23, at page 1843.
This is volume 2.
Oh, I'm sorry.
Right. Now, I think for me, we've just started to go too fast. Can I just help us all? I hope we're going back a step. You just gave us some page references in a different document, and I didn't actually manage to write down what that was.
C5. It's the OEP.
It's
report.
tab 5 of the core bundle, is it?
Yes, core. Yeah.
So it's the OEP
Report.
Oh, it's the report, not the
Yeah.
intervention.
Right. Okay. Right.
That
I've got those
DPSIR.
references.
And that's references to where they effectively adopt all
Exactly right.
the CIS document references.
Exactly.
Is that
Yeah,
Exactly.
okay.
They yes, exactly right.
Right. Fine. Now we're going to tab.
Now tab 23. I'm sorry.
No, that's right. But I think
You saw some of this yesterday. Page 1843. Sixth component development of the RBMP. Fourth paragraph. The plans are not the principal mechanism for implementing measures to achieve the environmental obligation imposed by the plans. The measures are to be set out in programmes of measure, paragraph 11, to be adopted by each RBMP. Programmes of measure will then be summarised in the RBMP. The role of RBMPs is broader than this. Fourth paragraph. That completely inconsistent with the Secretary of State's reading of other bits of this document.
And you've just read from page
1843.
1843, thank you.
Fourth para. The plans are not.
Yeah.
And then at 1864, I mentioned the word gap analysis. That was what Mr. Kelton was reaching for. Have you done a gap analysis? That's on 1864. There's a whole table there of what a gap analysis looks like. And if you see sources, third entry on the table, WFD Annex 2, 1.4 to 2.5. Those are the bits I showed you in Annex 5 of the water body specific assessment you have to do to inform new measures. Then you have at tab 24 Commission document telling member states how they should report to the Commission, which at 1889, somebody has helpfully yellow highlighted the passages. Lower bullet highlighted River Basin.
Sorry, we're now in
it's Commission, I don't know the right word, guidance, so they call it guidance.
This is tab 24, is it?
Tab 24,
Which we've not looked at.
not looked at before.
No idea what this is.
It's the Commission telling member states how to report to the Commission.
Right. So,
1889, all I need is the top of 1890.
yeah, I'm sorry, just to pause you just for a second. We don't have a cover sheet or a front sheet for the document, do we?
We don't, I expect.
And so if we can just know what the document is called.
But I'm just looking for the purpose of the document. The purpose of this document is to provide member states with guidance on how the various aspects of water regulation
Yeah,
should
yeah,
be reported to the Commission.
but I'm so sorry, but what is it?
Well, I'm inferring from that opening that it's Commission guidance to member
Yes, no,
states.
we're looking for the title.
It's what the document's
If you're
called.
going to refer to it, we need to know what it is. Is it on the in the content?
Yeah.
WFD reporting guide. I don't know if that's the proper title.
It also has a watermark at some pages as a header at the last few pages, which says
We'll try and get you the title
final
page.
draft,
So this-
version 6.
Yeah.
I'm taking a very small point from it, but we'll get you the title page.
Yes, would you please?
Top of page 1890. Basically telling member states to report the summary programme of measures to the RBMP, and then says reporting of measures at a water body level will be disproportionate and not useful at EU level. So first of all, measures at a
That's
water.
a statement of the obvious.
Yes, but it
I don't think we need that.
well, my lord,
Okay, it's a small point.
it explains in part why very little can be inferred from the Commission's response to any of this across the member states, because they are not asking for or getting anything below RBMP level. And what's notable about that is that you had a debate about that yesterday. Lord Justice Fraser asked about the evidence. It's Mr. Chandler. I'll make it the right person again. Tab 9 in the supplementary bundle, which is Mr. Chandler. At paras 10 to 12, when he slips into the mistake that I described earlier on, which is to treating our case as arguing that there should be water body measures, level measures in the RBMP, which is not our case. He says no member state does what the claimant says should be done, but that's not what the claimant says should be done.
Can you just give me the reference?
It's Chandler. It's supplementary bundle tab 9, page 253, paras 10 to 12.
Para 12.
My lord, can I just note that you've had no submissions from either of the other parties on their written administrative unworkability case, which the judge rejected. We say we should reject. 2, we dealt with that paragraphs 83.
That was also to some extent in the OEP report, where they've been told by the it needs some redefined staff, it would take 18 to 24 months. It's not suggested it would be impossible.
Yeah, exactly right. And
Well, to be fair, just to the other parties, this question, I haven't gone back and checked this just now. Do their responses to the OEP traverse this ground or not?
no, that is the point my lord just made.
Yeah, yeah, but they put
It's
in
hard work. Hard work is the.
Well, the OEP said what it did, but then of course they came back.
So look, I don't think they traverse it in that sense. I think the other point to mention is this: if one's looking at administrative unworkability as a proposition or how hard this would be, as we've indicated, we've only sought to quash the plan in the very limited way we've described, and that means the rest of the 22 plans are intact. So there's
an effect point of principle.
absolutely right, absolutely right. Well, but if it's
a bad point.
it's dealing with, we say, with a bad point against us anyway. That the point sits there. Finally, my lords, can I just take you to? We were looking at that, mentioning the OEP.
Scott 3, Mr Scott's third witness statement touches on what's been.
But again, we say it doesn't come anywhere close to making anything like the kind of threshold that the court would need to displace the clear words of the legislation.
Yeah.
And finally, subject to anything that's prompted from behind me, the government's response to the OEP, which you have in core bundle tab 2, it's the back of core bundle. I don't mean core bundle tab 2. I mean core bundle tab 5. Core bundle tab 5, page 302, was not the response in the litigation, but the response in the statutory OEP process. 1.2 on page 303. Government agrees there has been insufficient progress towards existing water environmental objectives over time in the current regulatory framework. Increased action, investment, more effective management is required. We would agree with that. And then page 306, water body specific measures. Recommendation 1, we say stating the law, a new measure should be time bound and water body level specific. It's a requirement in WFD that all new measures must be implemented within 3 years. Government supports the view there needs to be a renewed focus, etc. And then they pick up the point we were just talking about. The EA is estimated review of nearly 5,000 water bodies would occupy a substantial number of EA staff, diverting their duties to approximately 18 months. So they accept, if that's the right word, that proposition. But we say that's not the consequence of this order. It may feed into the next cycle, but it's not the consequence of this order.
That's a cycle which is not covered by legislation.
Well, there's a discussion to be had to see what happens with that, but yes.
Right. Thank you.
My lords, unless I can assist further with perhaps 30 seconds to go, I'll stop.
Thank you for coming in.
We say you should dismiss the appeal for the reason the judge gave, as set out in our skeleton and supported by the OEP.
Thank you very much, Mr. Paul.
Some furniture. Thank you. This one as well. We started off by identifying the issue.
Yeah.
The issue is one of principle, and this is in fact fairly narrow. As I also indicated at the outset, there are other matters arising from these instruments which may require resolution, and we've touched upon some of those. My reply is very focused on the issue, which is whether or not measures such as those in this programme of measures are legally sufficient. We've been taken to only one European case in this regard, and what is suggested incorrectly by the association is that the Secretary of State's case is that all that is required is something which is programmatic per the state's submissions in the visa case. That's not our case. It mischaracterises the Secretary of State's case. In fact, there is no problem at all from the Secretary of State's point of view with what is said in the visa judgment. Because the issue in this case is about the measures and what their relationship is with the environmental objectives. And as has been clear throughout these proceedings, there is nothing between the parties as to the fact of environmental objectives at water body scale. The error in the submissions from the association is to work backwards from that agreed point to a submission that the programme of measures must address each water body. Of course, as we've identified during the course of this hearing, we're perfectly content with there being measures in respect of individual water bodies, but that's not the legal question. I want to just develop that a little further by reference to the submission that was made to you about the OEP's intervention and the obligation of result. The obligation of result point is one that was addressed within our response to that intervention. And if we could turn up, please, from the core bundle. Paragraph 14 from our response, which we find at tab 6, to which the court was taken. Found at page 317. Page 317 in tab 6.
Yes.
Rather like the directive, the paragraph needs to be read as a whole, not selectively. There is no concession as to an obligation of result in that third line. The sentence, the one-line sentence, however, that is all in the context of making the programme of measures operational, is an important part of that paragraph, emphasising what the context of it is. And that is why the Secretary of State says in this paragraph, within management plans, that each water body is set environmental objectives. The programme of measures is required to address the objectives. How it does so is a matter ultimately for the Secretary of State, and that is my submission. So long as they are reasonably satisfied that it will achieve those objectives. What wasn't alighted upon in submissions was the point about the language used, which is with the aim of achieving. That is not language which is consistent with an obligation of result. It would be very easy for the directive to say so. And one can think of other directives where that is very clearly set out. One thinks of the learned judge below's very considerable success at the bar in respect of air quality. Air quality directive, very clear. This is the concentration of nitrogen dioxide, etc., which must be achieved. That's not what this directive does, and that's not what paragraph 14 accepts in terms of an obligation of result. I want to turn then to point sources upon which some submissions were made in a number of ways, and I'm going to try and bring these together in one submission, because it flows very much from the point I've just been dealing with in respect of the OEP. Because what we're saying in paragraph 14 is that we, of course, need to be reasonably satisfied that the programme of measures will address those objectives. And the point source part of the directive is an excellent way of understanding how the programme of measures goes about doing that, because the programme of measures on the terms of the directive plainly includes national measures, including legislative measures, such as the 2016 regulations. First point. Where those regulations themselves are implemented, case-specific, water body specific, and by reference to changing circumstances and by reference to review, the measure from the programme of measures has necessarily imported that flexibility. As I have indicated just this morning, there is in the authorities bundle the Secretary of State's guidance in that regard, and just to make my submission good, I'd invite the court please to take up the first volume of the authorities and go to tab 16, first volume of the authorities, tab 16, where one has the frontispiece to the environmental, page 474, frontispiece to the environmental permitting core guidance in respect of these regulations. The court has been supplied with only extracts, and I take the court only to make that submission I've made good to page 488 and 489, which has the main heading, ongoing review, and the subheadings, variation of conditions by the regulator, and the subheading, permit reviews. And simply draw attention, so far as the specifics of permit reviews is concerned, to 1142 second bullet point at 489. Which explains that those regulations don't specify the period of reviews, but rather that they are to be carried out in the light of experience, etc. What is not challenged in this case at all, nor could it ever be, is the adequacy of the underlying monitoring, characterization, and assessment, which is at water body level and has allowed the making of environmental objectives for each water body level. And what one has, therefore, is both the mechanism, it is a measure in the programme of measures in this 2016 set of regulations, and the data on which to carry out review and variation as needed. I want to, at the same time, pick up at the point source, diffuse source distinction to see if I can assist in that regard to some extent. If we could put away the authorities bundle and turn please to, in fact, I do apologise, keep the authorities bundle and we'll turn to the directive in tab 1 and go to Annex 7, page 88. Annex 7, page 88. Which perhaps is, if I'm taking the court to something which is already obvious to it, I apologise. Page 87 is probably where to go to first of all, because that takes us to Annex 7. And at A2, we see the reference to estimation of point source pollution, and then the second indent, estimation of diffuse source pollution, and then it turns to quantitative status and then impacts of human activity. So those are the four matters, and the first two are point source and diffuse source. The court will find, if it cares to do so in due course, that reflects exactly what was set out by the Commission in the document which gave rise to this directive, and to assist with my Lord Justice Holgate's question, that there is a substantive and helpful description of point source and diffuse source pollution within that document, showing very much that that is how the entire scheme was set up. And the page reference is for the document itself, it's at 608, and for the particular reference to diffuse and point source, it's at 613. There are two helpful paragraphs there which describe point sources and diffuse sources.
Could you just give me the tab number as well?
It's tab 1919.
Yes.
Which brings me to deal with just two more points. One is in respect of what was really submitted under the heading of gap analysis and the way in which review is undertaken. In the same way that I've referred to the 2016 regulations as bringing into the framework scope for review, which is specific, it's also necessary for the court to keep in mind that the directive makes express reference to and is intended to be read alongside directives such as the Habitats Directive and therefore domestically the Habitats Regulations, but which will require review of consents for areas which are protected areas. Similarly, so far as the point about gap analysis is concerned, the WINEP is a process, not a process which emerges immediately from a legal instrument, but it's to give effect to legal obligations, which itself results in consultation, proper discussion of what should be done, where and when, and what can be done. So to submit that the gap analysis is absent is, in the Secretary of State's submission, not supported by the clear legislative framework. Lastly, I want to pick up a number of points which emerged by reference, and I can pick them up collectively via the witness statement, the second witness statement of Mark Scott. So if we could turn please to the supplementary bundle, to that witness statement. Behind tab 8, and the first to pick up behind tab 8 is to turn to paragraph 42 at 238. As a point of reference, which in my submission is consistent with what I've just submitted about the gap analysis, what is set out there in terms of the measures to be provided for. Go over the page onto page 239. Those references and that evidence in my submission is consistent with the submission I just made. I want then to deal with, from this witness statement, the point about extended deadlines, which is part of the submissions you've just heard. And in that regard, could we turn please to paragraphs 89 to 93, turning forward within the same witness statement. Which has the heading in respect of regulation 16.7, and I draw attention in particular to what is said at paragraph 91 in respect of extended deadlines. second sentence, the summary programme of measures published in the 2015 plan consisted solely in relation to water body status, the measures to prevent deterioration, or those that are envisaged as necessary to bring progressively to the required status by the extended deadlines. And then 92 then turns to the review. The review of measures carried out as part of the ongoing river planning process is therefore a review of the measures envisaged as necessary to achieve the water body objectives. And that, in my submission, is essentially where the two approaches which are urged upon the court are rather encapsulated. On the association's case, it's that the programme of measures, as would be summarised in the plan, becomes something which addresses some 5,000 water bodies in great detail. And that immediately prompts the question, what then is the proper function of a river basin district? Having done that, thinking back to the recitals to which I took the court at the outset of this case, which made very clear the fundamental importance of integrating and standing back and addressing in a particular locality or region the pressures which are identified within that region. Where does it leave that strategic planning for a river basin district? It turns that strategic planning for a river basin district into something of an entirely different scope and function, which in the Secretary of State's submission is not supported either by terms of the directive, nor by such materials as disclose what its intention and purpose has always been. My Lords, that is a minute to one.
Thank you very much, Mr. Kinman. Thank you. Do you have any questions? Maybe one.
Now, I've got just one question. If you could look in the authorities bundle 1, please, under tab 17. Which is the River Basin Planning License document.
Yes.
And if you turn to page 538 in there, which is paragraph 40.
Yes.
Which basically says effectively says what measures are.
Yes.
And if you look within Mr. Scott's second witness statement, which I think is one of the documents we've most recently been looking at, which is at tab 8 in the supplementary bundle.
Yes.
And turn to page 236.
Yes.
And look at his paragraph 27. I don't intend to pursue this too far, but just to ask you, that reads to me in paragraph 27 as explaining something other than the sort of measures as they're described in the first bullet point of 14.1.
So 14.1 reads that the regulations refer to both actions and the delivery mechanisms as measures, actions and delivery mechanisms. The terms are used as follows here. So measure is used to mean any action which will be taken on the ground to help achieve the objectives, and we have to read it with the second bullet point to understand it. Mechanism, in contradistinction, is going to be used to mean policy, legal and financial tools, and we see listed a variety of matters, the types of which we've seen examples of. My submission about the comparison of the two sentences, well, the one sentence in paragraph 27 and section 14 is that the guidance is simply being very clear about the way in which it's using particular words. I don't detect there any difference of approach.
Right. David, you don't have any questions? Well, thank you very much, Mr. Kinlin. Thank you. That completes the submissions. We're very grateful to all council, and I mean all council, both those who have addressed us and those who have not, but have played their own role in preparation and so forth, for the way in which the case on either side has been presented to us. We're very grateful for the clarity of the submissions made. We are going to reserve our judgment. A draft of it will appear in due course. For the purposes of the parties agreeing a draft order and making any submissions to us that relate to that draft order, insofar as it is not an agreed order. The draft will of course be confidential to those to whom it is sent. There will be an embargo in the usual way, whose terms must be strictly obeyed, lest there be the necessary consequences if they are not. We shall endeavour, of course, to produce our judgment as soon as we reasonably can, but we make no promises as to its precise timing. Thank you all very much.
All rise in favour.